Well, if you're all ready, we can get started.
Sure.
Good evening. My name is Simona Smith. I'm a CLE Program Manager at the New York State Bar Association. We would like to welcome you to this evening's program, Impeachment Redux, Impeachment, the 25th Amendment, and Criminal Prosecution. Today's program will run from 5 to 6 p.m. and is sponsored by the Committee on Continuing Legal Education. I would like to hand over the webinar to Hillary Jackmans, who is the president of Jackmans Consulting, LLC, a boutique government affairs practice. She works with clients to determine their policy goals in Washington and New York and to craft an appropriate and effective advocacy plan at the state and federal levels. I now hand over the webinar to Hillary.
Thank you very much. Thank you everyone for joining today. And more importantly, for this purpose of conversation today, I'm also the policy director for the New York State Bar. So thank you for having us today, and thank you for joining in the second in NYSBA series on the presidential election. Exactly 3 months ago, on October 13th, the members of our task force on the presidential election spoke on the laws governing the transfer of power. A lot has happened in the intervening 3 months. The election was held on November 3rd. 5 days later, the media declared Joe Biden the winner of the presidential election. In that same election, Democrats lost seats in the House, but maintained a slim majority. Control of the Senate remained unknown until 2 months later, when an unprecedented double senatorial election in Georgia determined Democratic control of the upper chamber. And throughout these days and weeks, anger, distrust, and lies about the election were advanced by President Trump and his devoted followers. All this anger culminated exactly 1 week ago today in a brazen attack by a violent mob at the US Capitol that resulted in 5 dead, including 2 US Capitol police officers. Almost immediately, we started to hear cries of impeachment, sedition, coup, censure, and invoke the 25th Amendment. But what do all these words really mean? We are fortunate to have 2 legal scholars and members of the NYSBA Task Force on the presidential election with us today to do a deeper dive into these and other issues. Joining us today are Jerry Goldfeder, Special Counsel at Strzok & Levin, and an adjunct professor of election law at Fordham Law School, and Jed Shugerman, also a professor at Fordham Law School and the author of a book that traces the rise of judicial elections, judicial review, and the influence of money and parties in American courts. Our discussion today could not be more timely. At approximately 4:30, just 30 minutes ago, behind 7-foot security fences and multiple metal detectors, and under the protection of hundreds, if not thousands, of additional federal and state security troops, the House voted on a single article of impeachment, willful incitement of insurrection. The final vote was 232 to 197, with 10 Republicans joining the vote to impeach. So what does this mean? Where do we go from here? To explore these topics, I am pleased to introduce Jerry and Jed. And Jerry, I turn it over to you.
Well, thank you so very much. And thank you all for joining us today. No matter how you feel about this President of the United States, and no matter how you feel about the article of impeachment and what the House just did in its vote, it's a obviously very sobering moment for the United States of America. It is rare for the power of impeachment to be used. It is even rarer for it to be used against a president of the United States. And of course, it is unprecedented for a president to be impeached twice. With the vote today, the articles will go over to the United States Senate. The Speaker of the House has already appointed House managers for the trial of Donald Trump in the United States Senate. As I'm sure everybody here knows, all that's required in the House of Representatives is a majority vote to impeach. And in order to convict an impeached person, 2/3 vote is required in the United States Senate. We already know that Leader McConnell, who continues to be the leader of the United States Senate until January 20th, he has announced that the trial will not start until Mr. Trump leaves office. So the first question we have is, can we try an impeached civil officer, whether it's the President of the United States or whoever it might be? Can that person be tried by the Senate after they're no longer in office? And I commend to your attention two articles before we hear from our constitutional scholar, Jed Shugerman, on his view about this. There have been two recent pieces that have been written. One by Michael J. Gerhardt, who's a professor of law at the University of North Carolina Law School, who basically says, yes, and after a person has left office, they can still be tried for their impeachment. And former Judge J. Michael Luttig wrote in today's Washington Post an article that argues for the position that the Senate really is without power to try someone who's been impeached after he or she leaves office. I will point out that two people in our history, Senator William Blount in 1797 and Secretary of War William Belknap in 1876, were in fact tried after they left office. So there's some precedent, but it's precedent from years ago. And just because it was done doesn't mean it's constitutional. So the first question we have is, now that we have President Trump impeached for the second time, and McConnell having said he's not going to do anything, the Senate's not going to do anything just yet, can the Senate hold a trial and debate whether or not Trump should be convicted after he leaves office? Jed, what do you think?
So thank you, Jerry, for the invitation to be part of this conversation. And I appreciate just also the New York State Bar Association for being able to put this together quickly in such a timely way. I knew that, I'm sure you all knew that 4 p.m. would be the vote. And let me also say that, this really is an historic day. First of all, James Harden is going to the Brooklyn Nets. That's also today's breaking news. In fact, maybe that's more of a surprise. We all knew there's a little bit of, there's something a little anticlimactic about the day, in that we knew that the House Democrats had the votes lined up. We knew there was a small number, some number of House Republicans, including the biggest name, Lynn Cheney. But let me address this point directly, Jerry. I'm frankly astonished that someone as respected as Judge Luttig, who had been on every shortlist for the Supreme Court, would write such a weak, thin article with zero historical evidence to support what I thought was a judge who was committed to original public meaning. I think there have been a lot of bad arguments floated in the last 4 years on both sides. This is on the top 10 list. Let me be clear. There is no there's no clarity in the textual argument that Judge Luttig puts forward. He simply, I encourage people to read it. When as Chief Justice John Marshall said a long time ago, that the Constitution does not have the prolixity of a legal code. It's meant to be expounded, but it's not supposed to spell out every detail. There's nothing in the text that suggests that impeachment is limited to sitting officials. In fact, it would lead, many people have pointed this out today, it would lead to an obvious absurdity that someone could avoid, if someone knew that the votes were coming in while the impeachment, like for example, at some point today, Trump could have resigned to have avoided what he knew was an impeachment and then prevent disqualification. Now, some people might want to test it out, but Nixon, out of deciding that he wanted to save himself the embarrassment of being impeached and removed, resigned in time. Well, it would defeat the prospect of any disqualification for someone to to resign as soon as they were impeached. I mean, not even before the impeachment, but after they were impeached, so that the removal trial could be preempted. This does not make sense. Second of all, exactly right, Jerry. The points about Senator Blount and Secretary of War Belknap from the first one is, I think, the most important. Senator Blount was impeached after he had left office, and no one raised this point. Right, that would have been the point in the 1790s. And keep in mind, many of the people who were part of the Constitutional Convention and the ratification debates, exactly 10 years before that, in 1787, were there for this debate, and there was no disagreement on this point. So I think it is actually clear. Someone can be impeached, removed, and disqualified, and that process of the trial can happen after they've left office. Otherwise, disqualification would be a dead letter in the Constitution.
So let's just be clear about one of the points that you made, Jed. So it's a two-part process. This assuming Jed is right, that the Senate can go forward and hold a trial. It's a two-part process. The Constitution allows the president to be convicted and removed from office. Obviously, he's not going to be removed from office, but the conviction becomes the central aspect of the exercise of that authority. And then there's a second vote, if the Senate so chooses, by majority vote. The conviction is 2/3, and then by majority vote, pursuant to the rules of the United States Senate, can be barred. The impeached and convicted person can be barred from ever holding federal office. And I think that's probably the political purpose of going forward with it, but it remains to be seen what the vote is in the United States Senate on the conviction. And then, of course, only then, if they convict, can they deal with the issue of barring him from future office. I've gotten that right, Jed?
Yes, that's right. What's interesting, though, just maybe you said this and I missed it, was the current Senate rules set the threshold. Obviously, the Constitution says it's 2/3 vote for removal,
Right.
but the Senate's current rules say that you still need that 2/3 for removal, but here you need 2/3 for conviction, not removal, but then 50 votes for the disqualification process.
Saying 50 votes is because the vice president, of course, would break that tie.
So Jerry, I see questions in the chat, and this is something that I do not have a clear answer for, but it is a question of who would preside over that trial and whether the vice president the vice president is not presiding if the Chief Justice is conducting the trial.
Yeah, you're quite right about that. So she couldn't break a tie.
I think that's right. I think that they knew that this was the conflict of interest in a vice president casting a vote to become president. So in this case, it's a 50-50.
That's right. You're absolutely right about that.
Right. And so if it's 50, I think then if there's no tiebreaker, Chief Justice Roberts can't be the tiebreaker.
That's right.
Think. So then you need 51 votes, and that is you need. I mean, certainly at this point, you're going to need Republicans to vote for anything to move forward from the Senate. But I think this means that you still now what's complicated is the reason why you have this rule is because the vice president with a sitting president has it as a vested interest, but Kamala Harris is not going to be president. And yet there still, I think, is an underlying logic here, which is when it's the president, it's just too close to the vice presidential role. Even if this wasn't what they intended, I would just imagine that it's automatically for president or former president that it would be the Chief Justice who's supposed to preside. But that's not obvious.
I think that's right. And that does present the conundrum of if there's a tie, what to do. Well, if there's a tie, then the vote fails in terms of barring him from office. But I suspect that if they go forward and convict him, it won't be a tie in terms of barring him from future office.
That's right. I think go ahead, Jerry.
I wanted to ask you, Professor Shugerman and I were on a Zoom yesterday for Fordham Law School, and he was addressing some of the issues related to the substance of the article of impeachment. And I'd like you to address that, the issue of inciting to sedition or insurrection.
Sure, Jerry. Thank you for asking. And we were just talking about on one side, Judge Ludwig, as a conservative originalist, was making some bad legal arguments. I'm frankly more troubled by the bad legal arguments coming from the House Democrats. So the background is, my understanding is that when this article of impeachment was being drafted last week, it was initially titled Abuse of Power. That's the same label, that's the same title that the House used for its first article of impeachment for the Ukraine impeachment process. When this facts, what the House did is they drafted the facts under that first article to spell out every element of bribery, but they didn't title Article 1 bribery. Now, my view is they could have. I think they should have. They should have had both Article 1 abuse of power and Article 2 bribery. But they didn't do that. Why didn't they do that? It's now, I think most people now, I think most of our audience probably knows, if they didn't know already, but has learned and probably knew already, that you don't need to have a statutory felony for a high crime and misdemeanor. We all know that's a term. High crime and misdemeanor comes from English history as an abuse of power. Now, it made sense to use abuse of power because that's the quintessential high crime of a public official, especially a president. Sometime over the weekend, and it's not clear who, when, why, or how, that title was changed to incitement of insurrection. And I and many other people immediately spotted this as an error. Why? The word incitement, even if this is not a criminal indictment for a criminal trial, words matter for law and politics. In fact, there's an irony here to say that for Trump, his words have consequences. His words matter in terms of the speech on Wednesday, and to then turn around and then be sloppy with the legal terms that the House Democrats used. And another irony is that of all the speeches that President Trump has given over the past year, the speech he gave on Wednesday was a lot less inflammatory than some of his other speakers. But I really challenge anyone to look at the actual words of Trump's speech and find anything that rises to incitement. And if you do, I want to ask you what would happen when the shoe's on the other foot, when a progressive speaker says something like, fight like hell.
Well, he didn't just say fight like hell. He said, let's go down to the Capitol and I'll go with you. Words to that effect.
Gary, I will die on that Capitol Hill. Telling his supporters to walk to the Capitol.
But let's keep it in context. Let's keep it, the fact is, it was clear that a lot of those people, because it was on social media for weeks, that they had intent to disrupt at the very least. And when we see what kinds of paraphernalia they were carrying, how they had guns, they put up a noose, and so on and so forth, are you going to say that he was not aware that they were going down to the Capitol to disrupt in a potentially violent way? Look, this is not a criminal indictment. You are right about that. And the words to incite raises First Amendment issues. This is a political charge. As we know, impeachment is a political process. And inciting, I think it's fair to infer that he was inciting people to do what they were there to do in any event. And we can even quibble over the characterization of insurrection, because that word could be bandied about pretty easily as well. But taken together in the context of what he said and what happened, impeachment becomes a political process. Now, you can agree or disagree, but it's different than a criminal indictment where you have to prove scienter in order to convict someone.
So Jerry, I'll say a couple of things. One is, as a purely strategic matter of politics, I think it failed. And I think we still have yet, I mean, so maybe you're right, but I frankly don't think you're right. But even if you were right, I'm not the person you need to persuade. You need to persuade Republican members of the House, and so you might say, well, they got 10. I listened to the debate today, and I can spot 3 others, and there are probably more, who identified this sloppy use of the word incitement as a reason they voted no. Now, maybe they would have voted no. Maybe this is just a convenient excuse. But why? And I think it's reasonable to ask that question. But I also think they happen to raise a reasonable objection, which is there was no statement that Trump made that you could identify as incitement. And maybe, Jerry, I'll let you think about this, but I challenge anyone here to give me a quote that they would be willing to stand by, that they would want to say is incitement, and that if something parallel happened to a Democrat or to a progressive, I say this as a progressive. So let me pause for a second, Jerry, and tell the audience why I care so much about this. As an American, as a historian of law and politics, throughout American history, it is most often conservatives and reactionaries who've used the language of treason, sedition, and incitement to criminalize the left, whether it was the 1790s and the supporters of the Jeffersonians, or in the era of abolition. I've been reading and listening to David Blight's biography of Frederick Douglass and how abolitionists were accused of incitement. The 19-teens and Eugene V. Debs being put in jail for treason and accused of treason and sedition and indictment. The 1950s and McCarthyism, Vietnam, 9/11, and the aftermath of so much of attacks on the left. The point is, Jerry, we're better than that on the left. We don't need to use the language of incitement when Trump is on an audio call calling the Georgia Secretary of State engaging in election fraud. Why was there not an article of impeachment titled election fraud?
I know.
I put that. So Jerry, all I'm saying is there are many reasons why you don't want to even go down the path of incitement. But I'll ask anyone in the audience, you find me something in that speech that Trump gave, that Trump said, and the things that they cited in that article of impeachment were things like fight like hell and go walk to the Capitol. I'm sorry, I don't know that telling people to walk by itself. Now, look, let me also say, Jerry, I think it's quite likely that over the next month or two, we will find out more. And if there may be evidence there, that I will be the first to say, okay, that sounds like insurrection because there was something concrete. But there's another point to make here too, which is we are seeing other kinds of stretching of provisions. Some people are calling for the 14th Amendment, Section 3.
Before you get to the 14th Amendment,
go ahead, Jerry.
let me just interrupt you because I just want to respond. First of all, I knew what you were going to say because I heard you yesterday on this, and I wanted you to explicate your view on this because it's very important. And here in New York, you don't know, you're in Massachusetts right now, but in New York, 100 years ago, the state legislature expelled 5 members of the Socialist Party because they were socialists. So we have a full history of anti-progressive actions. Let me put it this way: of criticizing those who are progressives, those on the left, and using their words against them. That is true. Everything you've said is true. Having said that, I think one needs to look at the context of what occurred that so riled up the House of Representatives to take this extraordinary action just several days before the end of the president's term. So that said, I do want you to address the 14th Amendment because it's another interesting issue that people have been raising.
Sure, thank you, Jerry. So this is, and this was cited on the House floor by some of the Republicans raising this concern about the words incitement and insurrection, because now there is an effort to cite so I talk a lot with my students about the 14th Amendment and due process and equal protection. I've never expected that we would talk about the other parts of the 14th Amendment that dealt with the legal relevance of insurrections, but here we are. So Section 3 says, I'm paraphrasing, but that anyone who was, and this is a direct quote, anyone who had been engaging in insurrection or rebellion, or had given aid and comfort to the insurrection, would not be permitted to serve in any federal or state office. This was all ratified right after the Civil War, right? So
the reason Jed is raising this, just to be clear, for those of you who don't follow every little aspect of what's going on, is that this is kind of like a plan B. If in fact the Senate doesn't convict and therefore they don't bar him from future federal office, or if they decide not to, even if they do convict and decide not to bar him from future federal office, the plan B is to use Section 3 of the 14th Amendment to actually bar him from federal office. That's the context. Sorry, Jed, go ahead.
Good, Jerry. And the reason why it's a plan B is the suggestion that the Congress could pass this as a disqualification, by a bare majority. They don't need the 2/3 of the Senate. They would be able to do the 50 votes they now would have upcoming in the Senate. And it's not. And Jerry, the other point is that people are not using this just about President Trump. They're also invoking this and suggesting it could be used to bar other people who are members of the Senate. I mean, people who were actually in the Capitol. I think there's a strong argument that they were engaging in insurrection. The argument that some people are making is that Senator Cruz and Senator Hawley were also engaging in insurrection or giving aid and comfort. And this is, I think, the same slippery slope or a historical misuse. That same thing, Jerry. People were using the phrase "giving aid and comfort to the enemy" to crack down and accuse of treason the liberals and socialists in American history. So I think that it is inappropriate at this moment to be suggesting that the 14th Amendment could be relevant for Trump or some members of Congress until some concrete, hard evidence of more participation. This isn't simply delaying the National Guard or being AWOL. I mean, these are all reasons to impeach Trump. I think those are all high crimes, abdications of duty. But I think Jerry, my concern is that we're seeing a lot of sloppy talk, misusing, throwing around a lot of legal terms that that we know can be misused in the future when the shoe's on the other foot.
Right. So let's look at yet another tricky issue. There's a movement by at least some people in the Congress to expel people who have voted against ratifying, confirming what the Electoral College votes demonstrated, that Joe Biden and Kamala Harris had won. That would require expelling over 100 people in Congress. Yet that argument is being made that they should be expelled. Of course, as some of you on this call know, that the House and the Senate are judges of their own elections and can expel members for, it's not clear, for a variety of reasons. It's happened very rarely, but it has happened. Do you think they should be expelled?
So it's a really important question, and it's a really tough question. So let me give you my quick answer here, which I think is also more likely to be possible, given the vote. So Article 1, Section 5, Clause 2 spells this out. So you need 2/3. The Constitution says you need 2/3 to expel a member, but it doesn't have a 2/3 rule for punishments. And we know that censure can be passed by a majority. My view is that you actually could suspend all of those members from serving on any committee. This is the move that I would make as a majority. I think that Ted Cruz and Josh Hawley should be kicked off of the Judiciary Committee permanently. I think it was a mockery of the idea of judiciary and justice that those two have any say about judges. And by a majority vote, I mean, you have to win back the Republicans, if they wanted to put them back on those committees, would have to win back the Senate. And I think it is quite possible to take 100 members of the House or more and tell them for some period of time, you don't get to, by a majority vote, you don't get to serve in any committees. But I'll go further than that. I think that if it were up to me, and I'm not a member of the House or Senate, nor will I ever be, I think that there is a reason to take some of the leaders, especially Hawley and Cruz, and to have them and to push to expel them, not because of the 14, not because they engaged in insurrection, but because they have been delegitimizing American democracy. And I wrote a piece in Slate. I actually wrote it before the Wednesday riot, before the Wednesday insurrection. But I said, if you're a student of American history, we've seen this before. In the 1850s, pro-slavery and anti-slavery forces engaged in local elections, and it's called Bleeding Kansas. And there were massacres in Kansas because mostly the pro-slavery side rigged elections, and there were two different legislatures, and then there were massacres all over Kansas throughout the late 1850s. It was all predictable. Pipe bombs, Pittsburgh, El Paso. It's so many different examples of the violence. We've seen Charlottesville. How about the fact that armed white supremacists took over the Michigan legislature and then plotted to kill the governor? We could run out we could use up the rest of this call to talk about how all of this was foreseeable. My view is that it's necessary to defend democracy, to expel someone like Senator Cruz and Senator Hawley. They don't have a birthright to sit in the Senate. Let Missouri and let Texas have their representation after Cruz and Hawley have been expelled from the Senate.
But why do you pick out Hawley and Cruz when there were over 100 members of the House of Representatives who took the same position and argued just as vigorously as they did?
So I think it's hard. Sometimes in law, we understand that both deterrence and the idea of corrective justice depends sometimes on making an example out of the leaders. And I think the entire dynamic changed when Josh Hawley broke with the rest of the Senate and validated. I mean, Hawley played a fundamentally different role than anybody else in his stance, in taking the lead in the Senate. I don't think I can identify any particular member of the House who had any singular role like Josh Hawley. But Ted Cruz also played a sort of second role, breaking through there. So I do not have a bright line for you, Jerry, but that's also part of why this is a political process. Why it's
well, so it is a political process, and if we were defending either one of them, we would argue that their speeches on the floor of the Senate or on the floor of the House was pursuant to 3 U.S.C. 15, the procedures whereby the votes are taken out of the envelopes from each state, and they're tallied. And their view was that there were irregularities and they wanted to have some kind of an audit. I think it was disingenuous, but let's assume for a moment, disingenuous, I'm being very generous myself and very polite, but let's assume that they believed it. In some part of their being, they believed it. And by the way, they're political actors. So whether they believed it or not, they were playing a role on January 6th, whereby people can vote yes or people can vote no. That's why we send them to Congress. They can come up with the most cockamamie reasons that some of them have come up with, and they could take a position and they could argue that there was sufficient irregularities and therefore the Electoral College votes shouldn't be counted. I don't think it has any merit, but even if we don't think it had any merit, that was their position. And that's their role as a member of the House or a member of the Senate. They should be expelled for that?
Yes, because Jerry, I appreciate your I appreciate your invocation of context when we had our first conversation about Trump and insurrection. So, as I'm sure you know, there's a little devil's advocate. We've had this conversation about why it was great. My view was, and we've had this conversation, that I thought that Democrats were getting too upset and too harsh about the lawyers who brought the initial litigation, the Trump lawyers litigating through November. So there were something like 60 different steps of this litigation. Many of those steps in federal and state court were procedural, but many of them, I think my estimate was something like 20 of the 60 or something, over a dozen of these court cases looked at the substance of these claims, and there wasn't a shred of evidence. In fact, after all of this litigation for 2 months, there has not been not a single piece, not a single episode of voter fraud for Biden. There is some question about 10,000 votes in Pennsylvania that came in because Pennsylvania allowed a later mail. Those are all. That's not mail. That's not voter fraud. That's states deciding whether to change the procedure. There are some examples of people who fraudulently voted for Trump. It would be one thing if that process had not happened, and then we show up on January 6th, and then there are new questions. But my view was at the time that it was good that the Trump lawyers went to court, because I think it was Oliver Wendell, I think it was Louis Brandeis who said that there's nothing like cross-examination. There's nothing like there's no disinfectant like sunlight. I mean, apparently, Donald Trump thought that sunlight literally was a disinfectant for the coronavirus, but I thought that the litigation did its job. So it is more than disingenuous for Ted Cruz and Josh Hawley and others to then show up in Congress to undermine the Electoral College. They had nothing. So my view is what they were doing was actually delegitimizing American democracy rather than raising legitimate questions about an election.
Well, you're just dealing with the merits here.
But if you know the facts, if the law is not on your side, if the facts are on your side.
No, I'm just playing the role that I often play in circumstances like this, being a contrarian, in order to flesh out the arguments. Obviously, I see that we have a lot of chats, a lot of questions on the chat. And Hillary, if you can apprise us of some questions, we'll give people an opportunity to have their say.
Sure, absolutely. I don't know if you guys were looking at the chat or you could just sense what the questions were, but you've actually addressed quite a few of the points that were raised, but let me just flag a couple of others for you. A couple of questions about the role the speech and debate clause would play.
What about that?
Good.
Well, the truth of the matter is they're protected in their speech when they're making these arguments. But Jed is absolutely right. There was no merit to their arguments. And it's never happened in our history that Electoral College votes have been overturned by allegations that have absolutely no merit whatsoever. What they were doing was, what they were attempting to do was unique and fundamentally destructive of the process by which we elect a president. Now, we could argue that the way we elect a president is anachronistic and we shouldn't be having we should not continue to have an electoral college, and we should not continue to have 50 or 51 with Washington, D.C., different election codes as to how votes are cast and how votes are counted. But we do have that process. And in each state, the votes were counted, and in some states were recounted, and even a third time in Georgia. And the states had a process by which, under their own laws, the results were shown to be that Biden won in those states. And Congress has the role of simply tallying the votes of the electors who voted in the various states. What they were doing was undermining that entire process, which perhaps gives us yet another opportunity in our history to say, Maybe we need some fundamental reform. Maybe this whole electoral college system that we have is so flawed and so rickety and so subject to abuse that we need to have direct elections like we have for every other public office in this country. What do you think, Jed?
Well, so let me say a couple things. I mean, in particular about the speech and debate clause. I mean, I think it's very important that the speech and debate clause immunity is there for a lot of reasons that go back to English history and to times where we've had tyranny before in Anglo-American history. And it's really important to have a space where members of Congress do not face any criminal penalty. I believe, if I remember this correctly, I think the immunity applies to civil immunity as well. But that's exactly why we have a process for expulsion, so that the members of the Senate, it's not a criminal or civil penalty. If you can't maintain the support of, 2/3 of your colleagues to hold your seat, that is the appropriate penalty. So I think that's the one reason why it's important to strip many of these people from their committees, or to have this conversation about. It's difficult. And I want to acknowledge, I don't have a bright line. I think it is really about making an example of one or two people in terms of expulsion. But I also, Jerry, I was skimming the chat, and we have a few questions about pardons as well, which I'm happy. I think that's really the next stage. Sooner than a Senate trial is going to be a debate about pardons. And also some people were challenging or asking me about what I would have done rather than use the phrase incitement of insurrection. And so I just want to state again, abuse of power would have probably gotten more votes in the House, but certainly I think you're going to see more of this problem in the Senate trial, where Senate Republicans might have been willing to disqualify. It's worth pausing to note that the weird dynamic between the House and the Senate, it's possible there will be more votes to disqualify Trump in the Senate in 2021 than there were votes in the House to even impeach him, because of the different nature and different time frames of 6 years versus 2 years. But also some of those Republicans want to run for president and would love to clear Trump out of the way. And McConnell is more supportive apparently of impeachment. But let me just, Jerry, do you mind if I jump to the pardon questions?
So I would like you to address the pardon question. So I think we can expect him to pardon himself, unless he decides to resign and have the new president, Mike Pence, pardon him. I don't see that, but it could happen. Or he could invoke Section 3 of the 25th Amendment and temporarily yield the powers of office, and have acting President Pence pardon him. I don't see either one of those things actually happening. I think what will happen is that he will pardon himself. I've been wrong before about my predictions, but I think that that's what will happen. So number one, I'd like you to address, Jed, if you would, whether or not he can pardon himself. And two, there's another little section in the Constitution saying that the president has, I'm paraphrasing, unlimited powers to pardon except situations relating to impeachment. So the question is, can he pardon himself? But also, can he pardon himself now that he's been impeached?
It's a great question. So first, so let me say one thing first about the argument about self-pardons. In fact, I saw in the chat that someone mentioned that no man can be a judge in his own case. And often that's what during the Nixon Watergate difficulties and conjecture about this, the troubles, right? During Watergate, there was this question, and the OLC wrote a memo where in 2 lines, they said no man may be a judge in his own case. I don't think that's a very good argument against a self-pardon, because the word in Latin, judex, J-U-D-E-X, is a reference to judging. And in our system of separation of powers, judges have special rules about recusal and conflicts of interest, and we don't have any of those rules for presidents and legislators. If we said that, if we applied this, we'd have to have we basically have to recuse all the members of Congress who take money from anybody, right? In many of these cases. So I find this to not be a helpful Latin phrase that resolves judging versus pardoning as an executive power. So, so Jerry, the argument that a Fordham colleague and I have made, Ethan Lieb, and with some other historical work and an article we wrote with Andrew Kent, is that we explored the clauses of the Constitution. We call them the faithful execution clauses. One is better known as the take care clause, that the president shall take care that the laws be faithfully executed. The oath, there's only one oath spelled out in the Constitution, and that's the oath that the president takes to faithfully execute the office. The framers of the Constitution knew a lot about English history. They knew how to write an oath that if they thought that the president was supposed to be somewhat royal or kingly, they would have borrowed the language from the coronation oath. They did not. Instead, they borrowed the language of faithful execution that was of ministers below the king, even mid-level, even the dog catchers of London took a faithful execution oath. So the point is, what does that language mean? For 500 years of English history up until the founding, that language meant that you took an oath or you had a duty not to self-deal, not to use your power for your own benefit. And that was spelled out in various statutes over a long period of time. And the Americans took these oaths themselves as part of the Revolutionary War, the Continental Army, and then as state and federal officials. Our argument is that a self-pardon is quintessential self-dealing, especially in the context we're seeing here, and it would be an invalid use of presidential power. There is another argument being floated that impeachment would stop the pardon power. And so the language in Article 2, it says that the pardon power, I always love to go right to the source here. So Article 2 is as the audience all knows, is the part of the Constitution that establishes presidential power. And it says that here we go, that oh gosh, let me just see if I can find it quickly. Here we go. Except that the power of pardoning, except in cases of impeachment. And so the argument has been that the pardon is the established meaning, the traditional meaning is that a pardon cannot stop an impeachment. Some people are now looking at that text and saying that you could read it the other way, that an impeachment can stop the pardons. Like the except in cases of impeachment is once the impeachment happens, then the president no longer has the power to pardon. That's what that exception means. That is simply not borne out by Anglo-American history. No one has suggested that meaning up until the Trump era. What that language meant, and this is, you can look back at the Constitutional Convention from August 25th, 1787, is what they were looking at was how to spell out the English tradition from the Settlement Act of 1701, where this was put into statute, that the rule was you could no longer plead, that you could not use a pardon and plead the pardon at bar of impeachment. Americans, the convention debated that language, but decided that that was too narrow, that they wanted to not only say that an official like a minister not only couldn't use a pardon to stop the impeachment in process, but after being impeached and disqualified or facing other punishment, couldn't later use a pardon to undo that punishment. And so that's that language that is now in our Constitution that many states use too. It's broader than, quote, bar of impeachment, but it simply means that, let's say William Barr, speaking of bar of impeachment, say William Barr had been impeached. Well, not only could Barr not have used a pardon to stop the impeachment, but he couldn't, after being impeached and removed and disqualified, couldn't use a pardon to get back into office. That's all that means. This is another, frankly, Jerry, this is another example, I think, of people being a little bit too driven by the politics of 2020 to try and find legal tools rather than actually doing the heavy lifting of historical research.
Well, I want to thank you for that analysis. That's really terrific. But I do want to say that what 2020 has done for us is that it's broadened the education of so many Americans. You know, up until 2020, there were just a handful of us who studied impeachment, who understood it, who looked at all the issues with regard to the 25th Amendment and now the pardon power. And people are talking about it now. You literally walk down the street and people are talking about it, which is a good thing. It means that people have a much better understanding of the electoral college process, of the whole electoral process, of the way Congress functions, what a president can do, what a president can't do. So in a way, there is a silver lining in this terrible situation that we have lived through in the last year, because it was actually a year ago that he was impeached for the first time. So Hillary, do we have any other questions?
Yeah, I've got three sort of thematic ones here for you, if you would like to address. One is, can you talk a little bit more about the Electoral College? We touched on it a little bit, but do you see a pathway where that might be changed, reformed? And if so, how would you do that? Also, can you talk a little bit more about the 25th Amendment? We kind of jumped to impeachment today because that was, that's all literally yesterday's news. But I think that's an interesting concept. And you do hear people speaking about that, like you said, even walking down the street. And finally, okay, so if conviction fails in the Senate, are there any other methods for removal of the president?
So I'll address the Electoral College. There have been approximately 700 attempts to modify or abolish the Electoral College in our history. And obviously none of them have succeeded. The last serious one was I believe it was in 1969. It requires a constitutional amendment. There is a process going on by which there is something called the National Popular Vote, which is a way of using the Electoral College in order to have the winner have the popular vote winner be the winner, rather than the Electoral College playing such a direct role, because there would be sufficient number of states who give their electoral votes to not the winner in their state, as is currently the law, but the winner of the national vote. So this national popular vote process, if enough states adopt it, could be a way of circumventing the Electoral College the way we have it now, without the requirement of a constitutional amendment, which of course requires 2/3 of the House, 2/3 of the Senate, and 3/4 of the state legislatures in order to have a constitutional amendment. I support the national popular vote, but I don't think it's a great idea, because in fact, it embeds the Electoral College even further in our processes in a way that then could be reneged by a variety of states, or withdrawn, because the laws, of course, can be changed after it's tried once or twice. So that's the Electoral College. And what was the second one? I'm sorry.
The 25th Amendment?
25th Amendment.
25th Amendment. So the reason we skipped over the 25th Amendment is because Pence said that he was not going to invoke it. There are two aspects, there are two sections of the 25th Amendment that are pertinent here, which is, number one, the president can him or herself say, I'm incapacitated for a little while, I'm turning over my powers to the vice president. Generally speaking, when a president, we've seen it in a number of cases when a president has gone in for a colonoscopy, for example, and they're going to be sedated, they've turned the powers over to the vice president. That's section 3 of the 25th Amendment. It's voluntary. And then when Reagan did it, and when he recovered, he signed a second document that enabled him to resume the power. So it's a way of dealing with a temporary incapacity. Section 4 is really what we've been talking about for the last few weeks, when the vice president and a majority of the cabinet can decide that the president is unfit. What does that mean? It's not really clear, but is unfit to continue to exercise the duties of the presidency. It was probably contemplated to be used when a president really didn't know that they were mentally unfit to continue, and the vice president and the majority of the cabinet could act on that basis. or if a president was incapacitated physically and didn't have the wherewithal, let's say, God forbid, they had a stroke, the vice president and the majority of the cabinet could do so. And Pence there have been obviously calls for Vice President Pence and the cabinet to do that. In fact, the House passed a resolution last night for him to do that. It was a way of avoiding impeachment, but Pence decided that for whatever his reasons were, not to invoke it. And of course, it itself raises a whole set of dicey issues. What does it mean to be unfit? Is President Trump unfit to be president in the sense that he's not mentally or physically capable of being president? One can argue he's totally capable of being president mentally and physically. It's just that the way he's conducting himself is inappropriate. And therefore, some would say that it's appropriate to characterize him as unfit. But that's a different definition of unfit than mentally or physically unfit. But we don't have to figure out whether or not the vice president and the cabinet acted appropriately, because they decided not to do so whatsoever. So that issue is off the table because Pence took it off the table.
And finally, the last question is assuming it does not pass in the Senate, that he is not convicted in the Senate, are there other measures available to bar Trump from running from office again?
The voters. Jed has already discussed the 14th Amendment. Right. Section 3 of the 14th Amendment some people would attempt to bar him from ballot access on the ground that he has violated his oath pursuant to the 14th Amendment. And a court would have to decide whether or not it's relevant to his alleged violation of his oath, and therefore whether or not he was no longer eligible to serve in federal office. But the surest way is, of course, the voters. So, because these other legal, I hate to say it, these legal technical arguments are not what moves people to support somebody or oppose them. It's generally their policies.
And this is why it's good that we will have a Senate trial at some point. The Senate trial may actually come up with beyond. I'm weighing in here based upon the arguments we're hearing now, based on Trump's words on Wednesday, and reasonable people can disagree about that. But a Senate trial with subpoenas, and maybe there are going to be people who come forward because of their own criminal liability and the deals they make, or just want to have the truth come to light. We may find out more details of concrete engaging in insurrection or giving concrete aid and comfort. And that would be either, now, so Jerry, this is what I want to jump in here on this last point. It could be a court that says that according to the 14th Amendment, Section 3, a court makes those findings and disqualifies Trump. My view is that Congress at that point might have the basis for passing a statute that Biden signs that legislatively says so. Now, you might say, isn't that a bill of attainder? Can Congress do that? And I say, that's why the 14th Amendment was passed. The fifth section of the 14th Amendment says that Congress shall have the power to enforce the provisions of the 14th Amendment. There are lots of statutes that have been passed to enforce the Voting Rights Act, the voting rights in the 15th Amendment, the 15th Amendment, Section 2. There are statutes that are passed to enforce equal protection. This would be a statute, with the exception granted by the 14th Amendment to the earlier Constitution's Bill of Attainder prohibition, to pass a statute that enforces the 14th Amendment, Section 3. The last thing I want to suggest, two small points. One is, Jerry, I agree with everything you said about the 25th Amendment and the Electoral College. What else can Congress do to try and remedy some of the Electoral College problems and the problems of the Senate's skewing of American politics away from New York and towards rural areas? I think this new Congress should make Puerto Rico and DC a state by a majority vote. And that would add members to both the House and Senate that would start to balance out the Electoral College a little bit. And in fact, I think you could make an argument that they could split California, but that's into North and South by majority vote. But that's a debate for another day. Finally, on the questions of pardons, the most important point is to take a step back from pardon panic. There is another limit on the pardon power, and people, I think probably the audience knows, but I think it's worth restating. A president can't pardon him or herself from state criminal liability, and there was already a lot of questions in New York City and elsewhere about Trump's state criminal liability, and I think it's worth saying maybe it's worthwhile. And I wrote this in Politico about 2 months ago, that maybe Trump's pardons are a gift, are sort of a silver lining or a surprise gift that allows the Biden DOJ to say, hey, let's just defer. This is federalism. It's too compromising for Biden's DOJ to prosecute the immediate predecessor, or for Merrick Garland, who I regard as a wonderful nominee for the Department of Justice. He's still going to be seen by many as sour grapes that the Republicans blocked him. I don't think that's really going on, or really true, but I can imagine that being a question. This is what's great about federalism, is that we can allow the states to do the investigation. And I think there's a lot of investigation that the DOJ has to already do of all these insurrectionists running around the country. So don't panic about pardons over the next.
So speaking of pardon panic, if he pardons himself, that might act as an incentive for DOJ to bring federal charges.
Yeah, I disagree.
There would be let me just explain it first. And then make the argument that his self-pardon is invalid and that they could prosecute him.
I don't think that's why people should get prosecuted. I think prosecution is
no. If there's grounds, if there's grounds for prosecution.
But then I don't think it should be because he pardoned himself that should. Jerry, I think that you're raising really important questions we're hearing, and I hear this argument a lot, that a self-pardon should be answered with a prosecution. I really want to push back on this argument, because I think I don't think we should use the machinery of prosecution to make legal points. I mean, maybe to express justice, sure, but not to make an argument in court that self-pardons are invalid. There's a better way to do it, which is the Office of Legal Counsel should update its memo that has 2 sentences about self-pardons, and should write a more robust argument that says Trump self-pardons are invalid as a matter of legal principles, but we will leave it to a matter of prosecutorial discretion about whether to prosecute Trump or to do what I suggested, which is it's actually better to defer and to federalism and let states do it, and not be compromised by Biden's Department of Justice making those kinds of legal arguments.
And this underscores the point that you made earlier, which is so very important, that we really don't want to criminalize politics.
That's exactly right.
I think our time is up, if I'm correct.
At 6:02.
I want to thank the Bar Association. I want to thank my friend, Professor Jed Shugerman, from flying in from Massachusetts to give us his analysis. We really appreciate it.
Yes, and thank you, Jerry, and thank you, Jed, and thank you to the over 400 participants we had today. I think it shows we've got a great interest with our Bar Association members, and this is obviously an ongoing topic, a discussion. So everyone stay tuned. We may be back with another in our series as these developments play out over the next few weeks and months.
Take care, everybody.
Thank you very much.
Thank you.
Thank you very much.
Thank you all so much for speaking. We really appreciate your time and expertise on this topic.
Pleasure.
Thanks for having me.